Welcome to this explainer. Today, we are unpacking some fascinating legal friction from a landmark 2005 Constitutional Court judgment out of South Africa. We're looking at the case of the Minister of Home Affairs versus Furry. Honestly, it's a brilliant case study in how the law wrestles with deep societal changes, and we're going to break it all down step by step, using the exact arguments and rulings from the court documents. So let's jump right in.
Before we get into the nitty-gritty, I want you to ask yourself a provocative question. Think about how deeply rooted the traditional concept of marriage is in global history. I mean, it goes way back, right? Now, take that ancient concept and smash it right up against a modern constitutional democracy, one built explicitly on the promise of absolute equality. What actually happens when those two immovable forces collide?
All right, here is our roadmap for today. We'll cover 1. The couple and the law. 2. The constitutional clash. 3. The meaning of marriage. 4. Arguments against inclusion. 5. The court's rebuttal. And finally, 6. The final verdict. Section 1. The couple and the law. Marie and Cecilia's legal barrier. Let's look at the human story here. Marie Adriana Fourier and Cecilia Johanna Bonthuyse were two women who had been recognized by their friends as a couple for well over a decade. They just wanted to regularize their union, celebrate their love publicly, and, take on the responsibilities that flow from marriage. But there was one massive legal hurdle standing in their way. They were both women. Now, what's genuinely surprising here is that the legal definition of marriage hasn't actually been frozen in time. The minority judgment in this case brought up a great point. Back during the classical Roman Empire, marriage was basically just a private contract based on consent. The state wasn't even involved. It was like, you agree, I agree, we're married. It wasn't until much later, around the Council of Trent in 1563, that the church really began to heavily control marriage. Fast forward to the 1961 South African Marriage Act, and the institution had evolved yet again, this time into a strictly secular, state-controlled thing. But despite all that historical evolution, the law in 2005 was stuck on a very specific binary. These strict definitions were the exact legal barriers that shut our couple out. The South African common law explicitly defined marriage as a union of one man with one woman. And if that wasn't enough, Section 30 of the Marriage Act literally mandated a verbal formula where the marriage officer had to ask if they take each other as lawful wife or husband. So practically speaking, there was absolutely no legal mechanism for two women to stand up and say, I do. Moving on to Section 2, the constitutional clash. Ancient definitions versus modern rights. This really illustrates the juxtaposition at the absolute heart of the case. On one hand, we have the pre-1994 legal landscape. This was an era where same-sex relations were totally denied legal protection, and get this, could actually land you in prison. And that reality is clashing directly against Section 9 of the post-1994 Constitution. Now, this new Constitution was a radical rupture from the past. It expressly states that everyone is equal before the law, and it explicitly prohibits the state from unfairly discriminating against anyone based on sexual orientation. Which brings us to Section 3, the meaning of marriage, the tangible and intangible stakes. Because we have to ask, what does marriage actually give you in the eyes of the state? Well, getting married secures a really vital trio for citizens: status, entitlements, and responsibilities. The law of marriage goes way beyond just putting a stamp of approval on a relationship. It binds spouses to reciprocal duty of support. It grants rights to the joint matrimonial home, meaning, one spouse can't just kick the other out on the street. It offers protections during insolvency, creates legal presumptions about children, and impacts literally everything from medical insurance to tax advantages. So to be shut out of marriage is essentially to be shut out of a vast array of everyday socioeconomic benefits. But look, beyond the property and the documentation, the real core of the issue was the intangible damage of treating same-sex couples as perpetual outsiders. Justice Albie Sachs captured this profound psychological impact perfectly. He noted that exclusion sends a really harsh message from the law itself. It basically tells same-sex couples that their capacity for love and commitment is somehow, less worthy of regard. It's a denial of human dignity, which, if you remember, is a foundational pillar of that 1994 Constitution. All right, Section 4, Arguments Against Inclusion, the Defense of Tradition. Now, to remain totally impartial here, we absolutely must look at the primary arguments presented by the state and the religious groups, like Doctors for Life International and the Marriage Alliance, who argued passionately against altering the law. There were four main objections defending the traditional boundaries of marriage. First up, the procreation argument, the idea that marriage is biologically defined by the potential of a man and a woman to have kids. Second, the religious argument, that altering a centuries-old institution would violate the religious freedom of those who believe marriage is divinely ordained as strictly heterosexual. Third, the international law argument, pointing out that treaties like the Universal Declaration of Human Rights specifically mention men and women. And finally, the pluralism argument, suggesting that, hey, if same-sex couples need rights, the legislature should just create a completely separate parallel family law system for them rather than messing with traditional marriage. So, do these arguments actually hold up to constitutional scrutiny? Let's find out in Section 5, the court's rebuttal, dismantling the objections. The court systematically dismantled these. Let's start with the procreation argument. The court highlighted a very simple legal reality. The state does not test straight couples for fertility before issuing a marriage license, right? To hold procreation as the defining legal characteristic of marriage would be incredibly demeaning to older heterosexual couples, to infertile couples, or to adoptive parents. Because of that, they ruled that procreative potential cannot be a constitutional barrier to same-sex marriage. As for the religious objection, it turns out the law actually already contained a surprising caveat. Section 31 of the existing Marriage Act expressly states that no religious minister can be forced to solemnize a marriage that goes against their specific religious doctrines. So, the court pointed out that giving same-sex couples the right to marry secularly or within affirming religions does not force conservative churches to perform those weddings at all. The sacred and the secular can mutually coexist. Then there's the international law objection. The court ruled that international human rights are meant to evolve over time, not remain permanently frozen in the past. The original intent of those international documents was to prevent terrible things like forced marriages, child marriages, and racial barriers. They certainly weren't designed to be a permanent ceiling on the expansion of equality, especially when South Africa's very own constitution explicitly forbids discrimination based on sexual orientation. And finally, the pluralism argument. The crucial takeaway here is that offering a separate system doesn't excuse discrimination in the main system. Yes, the Constitution does allow the state to recognize different traditional or religious family law systems. But that doesn't give the state a free pass to keep its primary default marriage law totally closed off to a minority group. When it comes down to the dignity of a primary state institution, separate but equal is fundamentally unequal.
Which leads us to our final section, Section 6, the final verdict. The gavel drops.
The ruling was definitive. The Constitutional Court declared that by excluding same-sex couples from the public and private status of marriage, the old laws completely failed the equality test. The failure of both the common law and the Marriage Act to provide a means for same-sex couples to enjoy the exact same status, entitlements, and responsibilities as heterosexual couples constituted an unjustifiable violation of their constitutional rights, specifically their rights to equality and dignity. This poetic language from Justice Sachs really captures the essence of the ruling. A democratic society thrives by embracing its diversity, not hiding it. He eloquently stated that respect for human rights requires the affirmation of self, not the denial of self. Our society is like this massive, rich tapestry, and acknowledging the diversity of sexual orientation simply adds an extra distinctive thread to that national tapestry. The ruling wasn't about erasing differences at all. It was about ensuring that difference is never used as an excuse for marginalization and stigma. I want you to think about this philosophical core as we wrap up. The court noted that the real test of a tolerant society isn't how we make space for things we're already perfectly comfortable with. No, it's how we accommodate the expression of what might initially challenge the status quo. So consider what you take away from this explainer today. If the true test of a tolerant society is how it accommodates difference, how does your society measure up? Thanks so much for exploring this with us.